Welcome, everybody. My name is Stavros Pantazopoulos. I'm the chair of the Low Interest Group of the Environmental Peacebuilding Association and also a researcher with the Toxic Crimes Project at the University of Helsinki and the Asser Institute at The Hague. I would like today to welcome you to the second occurrence of the joint webinar series we're putting together. On the one hand, it's the Low Interest Group of the Environmental Peacebuilding Association, and we are partnering with the IUCN-WCEL specialist group on environmental security and conflict law. Its chair, Karin Hume, and the vice chair, Daniela Dam de Jong from Leiden University. Karin, Professor Hume at the University of Essex, will be chairing today's panel. This will be the first part, and then we will move to the Q&A session where each one of you could pose a question. You can already do that in the chat box, or you can later on raise your hand and turn on your screen, and we will give you the floor. That's all from my side. And now I would like to pass the screen to Karin. Thank you.
Thank you, Stavros. And first of all, thank you to everybody for attending today. Dobry večer if you're in Ukraine. Hello to everybody else. We hope this is, we hope this is, and we trust this is going to be an interesting panel today. And I'm so glad that we can see so many people also interested in this topic as well. Obviously, it's a very important topic. We had wanted to bring together some expertise in relation to obviously armed conflict in the environment, which is the key to both of that, our specialist group, Stavros leading for NPAX and me and Daniela leading for IUCN. And we wanted to bring that obviously in relation to Ukraine, because there are so many horrors, of course, coming out of that ongoing armed conflict. And from an environmental perspective, so many impacts on the environment that so much, unfortunately, and obviously from our perspectives, that impacts the environment, and so many potential developments, hopefully, that we can discuss today. So I don't want to take up too much time with any in particular introductory remarks, but just to say that we do have the pleasure of introducing what I think is an expert panel today, a number of experts in their field to discuss this issue that really from day one, I think, has been there in the background. And it's for me, it's one of those moments like in the Vietnam conflict, and in the Iraq conflict, where we have such an assault on the environment. So it's really important that we discuss issues along the nature of accountability and ensuring accountability for environmental harm in relation to the environment. Okay, so I think, am I right, Stavros? Kicking us off today is Dr. Natalia Hendel, because unfortunately one of our speakers could not make it in the end today. So we've had to just jiggle things around a little bit. So we unfortunately won't be hearing from Richard Rogers, but we will go straight to Dr. Natalia Hendel, who is a research fellow at the Geneva Academy of International Humanitarian Law and Human Rights. Dr. Natalia is a professor of international law at the International Humanitarian University of Ukraine. She is a trainer on IHL of the Ukrainian Red Cross Society. She was a member of Ukraine's Interdepartmental Commission for the implementation of international humanitarian law from 2015 to 2017. And I believe, if it's still the same, Natalia, your title is Russian Ecocide in Ukraine, International Law on the Verge of Capabilities. So can I throw it over to you?
Thank you. Good evening. It's an honor to participate in this discussion. I hope my internet will be good for using Zoom. You have undoubtedly seen photos from the Kherson region. They do not convey the horror of what is happening in the catastrophic consequences of the Kakhovska hydroelectric power plant dam explosion. And this is just one, the latest and most telling example of the scorched earth tactic the Russian Federation is conducting, which has been incorporated into its policy of warfare. the polluting of mines in Donbass by the Russian occupation authority before the full-scale invasion, the seizure of shelling, mining of Ukrainian nuclear power plants by the Russian armed forces, the violation of all possible standards of operation of the Zaporizhzhia nuclear power plant, and the threat to blow it up, the senseless destruction of the Ukrainian energy infrastructure used exclusively for the needs of civilian population has caused and the inflicting severe catastrophic environment damage, and it is an over ecocidal war by Russia against Ukraine. Moreover, Russia is a party of to all major international humanitarian law treaties, including the Geneva Conventions for the Protection of Victims of War, the first additional protocol thereto, and the Convention on the Prohibition of Military or any hostile use of environmental modification techniques, and that did not stop the aggressor to violate all these treaties. Russian aggression against Ukraine has once again demonstrated the catastrophic consequences of war on the environment, and how powerless and insufficiently effective international law has proven to be in this case. The prohibition of environmental damage in Articles 35 and 55 of the first additional protocol was a significant but insufficient step to prevent these types of the methods and means of warfare. And this was evident in the probable explosion of Kakhovska hydroelectric power plants by Russian agents. The consequences of probable explosion of the Kakhovska hydropower plant done by Russian agents meet the criteria of widespread, long-term, and severe damage contained in Articles 35 and 55 of the first edition protocol, but such consequences are not criminalized among its grave breaches. As a specially protected facility containing dangerous forces are prohibits in Article 56 of the first edition protocol include only a text, make it difficult to qualify the probable explosion of the Kakhovska hydroelectric power plant as a serious violation of this prohibition. The shortcomings of the above article were also evident in the case of the seizure of the nuclear power plant and attempts at nuclear blackmail by the Russian armed forces at Ukrainian nuclear facilities. Also, explosion of the Kakhovska hydroelectric power plant qualify as extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and want only under Article 147 of the Geneva Convention on the Protection of Civilians Persons in Time of War. This qualification, which is not directly related to the environment, is important for applying at national level and criminalize this violation as ecocide under Ukrainian Criminal Code and as a war crime under Ukrainian Criminal Code too. In this case, the inevitability of punishment for explosion of the Kakhovska hydroelectric power plant as one example of the violation should be ensured in the International Criminal Code, and the first steps to do so have been taken. On the first day after the explosion of the Kakhovska hydroelectric power plant dam, the Ukrainian Prosecutor General asked the ICC to investigate this violation, and Article 8 Part 2A Rome number 4 of the Rome Statute makes it this possible. The reaction of to the explosion of the Kakhovska hydroelectric power plant by the Ukrainian authority was immediate. All possible resources were mobilized to help the victims and to minimize the consequences of the disaster. However, the consequences for the environment are of a regional catastrophe comparable to the Chernobyl disaster. For example, recently, President Zelensky, speaking at a meeting of European Council, underlined that if there is no strong reaction from European leaders and countries to the Russian crime at the Kakhovska hydroelectric power plants, it could give Russian terrorists a nerve to target the Zaporizhzhia nuclear power plant. Moreover, the reaction of the whole international community and the international justice system. This was stated in a statement by the Verkhovna Rada of Ukraine, which appealed to the United Nations parliaments and governments of its member states, international organizations and their parliamentary assemblies in connection with another act of terrorism by the Russian Federation by explosion the Kakhovka hydroelectric power plant. And in this time, the Ukrainian parliament appeals to the member states of the United Nations Security Council to support Ukrainian claim that the Russian Federation has violated the Environmental Convention and requests the United Nations Security Secretary General to convene a consultative committee of experts to clarify and assess the actual circumstances and environmental implications. This is a mechanism explicitly provided for in the Environmental Convention, which will help ensure an objective and independent determination of the facts surrounding the dam explosion. Ukrainian law enforcement authorities began investigating and documenting the crime in the first hours after the explosion of the Kakhovka hydroelectric power plant. Criminal proceedings were opened under 2 articles of the Criminal Code of Ukraine. First one, it's a violation of law and custom of war, which is equivalent to war crimes. And then another one is ecocide. The Criminal Code of the Russian Federation also contains the crime of ecocide. However, there have been no court convictions under this article in Ukraine. It was a dormant article. However, now about a dozen criminal proceedings on ecocide have now been opened in Ukraine, and the explosion of the Kakhovka hydropower plant dam is among them. The article criminalized ecocide as mass destruction of plants and animals, poison of air or water resources, and other actions that can cause an ecological disaster without revealing the concept of ecological disaster. In our opinion, the criteria of ecological disaster may be linked to the definition of widespread, long-term and severe damage in the Environmental Convention and or the first edition protocol. Undoubtedly, the consequences of Kakhovka hydropower plant dam meet the notion of ecological disaster according to the highest criteria, which could be the first edition of protocol. This qualification is, in our view, legally irreproachable and in accordance with the factual circumstances. Also, Ukraine as state can use the mechanism of the International Court of Justice to address Russian violations of the Stockholm Convention on persistent organic pollutants, or for another ecological conventions, the Convention on the Protection and Use of the Transboundary Watercourses and International Lakes, and the Convention on Biological Diversity, because Ukraine and Russian Federation are party of these conventions. In conclusion, it should be recognized that contemporary international law and international humanitarian law and criminal law as a part of it do not contain sufficient rules and mechanisms to protect the environment during armed conflict. All of the conventions that have been mentioned need improvement, primarily in relation to the protection of the environment and facilities containing dangerous forces. And in the international armed conflict caused by Russian aggression against Ukraine will, we hope, undoubtedly lead to amendments to international law, including the addition of criminalizing and defining ecocide under Rome Statute in the medium term. And now, and on the agenda is the on the agenda is the prosecution of Russian agents for all war crimes and crimes against humanity and crimes against nature and crimes against environment too. Thank you for your attention.
Diakio, Natalia, thank you very much. And I think that was a really rich, in such a short amount of time, I think that was a really good, rich mapping of IHL, of international criminal law. You talked about ecocide, and of course the developments globally, not just in the situation just of Ukraine, which has an ecocide law. So in the future, we'll be looking at this in the later presentations, the potential for this this notion of ecocide, this concept to be broadened, and yes, so many possibilities there. I think Kate, amongst others, will be discussing later, so I won't trample on your your topics there. So I want to move swiftly on then to our second presenter. This is Doug Weir from CEOBS, the Conflict and Environment Observatory. Doug has undertaken research and advocacy on the polluting legacy of armed conflicts and military activities since 2005. He has contributed to okay, he's sharing his screen. Sorry, that threw me then. Sorry, Doug. He has contributed to a wide range of domestic, regional, and international initiatives on conflict and the environment, and is currently working with international stakeholders on the environmental response to the invasion of Ukraine. Doug is moving us from the legal dimension there, the what is the law, what are the tools we can use in the legal sense, to how do we evidence, how do we monitor, how do we collect the evidence, for example, in order to make prosecutions, in order to make them happen, and to measure the impact on the environment. So I'm going to throw over to you, Doug, for what I'm sure is also going to be a really rich discussion.
Thanks, Karen. So yeah, good afternoon, everyone. I'd like to just present a few reflections on the challenges of environmental data collection in conflicts, many of which have been informed by our work to monitor the situation in Ukraine, but also with respect to the other conflicts which we study. So I'm assuming from Karen's shock, you can see my slides. So, so just very briefly, we're a UK charity working to increase the protection of people and ecosystems from the impact of armed conflicts and military activities. So at CEOBS, we collect data for four main purposes. So firstly, to increase public awareness of the environmental dimensions of conflicts, a topic which has historically tended to be a rather low priority. Secondly, we collect data to support the work of those assessing and responding to environmental harm on the ground. Thirdly, for accountability purposes, the focus of today's meeting, in spite of the current limitations, which, yeah, we'll hear more about, I don't doubt. And finally, we collect data to help strengthen norms. And it's notable that the recently updated Red Cross military guidelines on the environment and the International Law Commission's principles on the protection of the environment in relation to armed conflicts, which were agreed by governments last year, were both very heavily influenced by data from areas affected by conflicts, both in terms of motivating their development, but also along the way to ensure that they were accurate and appropriate and useful. So to provide some context to the data environment that we're looking at, in the last decade, we've seen this shift from the historic model of post-conflict environmental assessments to near real-time monitoring of environmental harm. It's a quiet revolution in how we document the environmental dimensions of conflicts. And while the greatest developments are in remote methodologies, we're also on the cusp of new developments in ground-based assessment, with the use of low-cost participatory data collection likely to expand in future. And of course, you can add the growing use of drones and drone footage into this mix. The shifts in remote assessments are largely due to the greater diversity and accessibility of Earth observation tools, coupled with the affordances of social media. And in turn, social media is also influencing, in many cases accelerating, traditional media coverage of conflicts. We'll increasingly see a much wider range of stakeholders gathering data on the ground, which can help to provide the ground truthing necessary not just for robust Earth observation, but also potentially data that could be made available for accountability purposes. At present, the difficulty in obtaining data on the ground increases the relative value of remote data collection. So all of this is being buoyed up by a rising tide of interest in the environment across societies, and then being reinforced by the monitoring data, which is enhancing public and political awareness, and also interest in the environmental dimensions of conflicts. Naturally, this has also begun to increase public and policymaker expectations around accountability. However, in this very dynamic period, data collection and storage is effectively being done on the fly. So as an example, we can look at how we responded to the full-scale invasion of Ukraine. So following the 2022 invasion, we initiated work on an incident database. Its development has been iterative and is ongoing. We had three priorities. So one was to inform assessment and response. Another was to inform our advocacy, work we do, speak to journalists and working with the media, but also we wanted to inform future accountability processes. So our main priorities with the database are to prove that something happened, verification element, when and where it happened, so temporal and geolocation, and then what the health and environmental risks of that incident might be. So we undertake a remote risk analysis on these incidents. The remote assessment and severity ranking we've developed is now being used by UN agencies to prioritize locations for field assessment. As you can see, this core work within the database sits within a wider process of which accountability and the political will to advance it are also components, which are all informed by this foundational work to collect the data in the first place. So in the database, evidence of environmental damage for assessment purposes can equally become evidence for accountability purposes. These scenes, which are from social media and satellite sources, detail different harms caused to the Azot chemical plant near Severodonetsk. The plant and nearby associated industries were caught up in the fighting in June 2022, effectively becoming its front line for a time. As social media coverage can be ephemeral, our database entries are archived daily with a German NGO platform called Mnemonic. A cryptographic hash is added to the content of each day's archive, and that helps to show that the imagery has not been tampered with following submission. In the case of the Azot plant, we only have remote data and satellites and social media imagery. But if you can merge remote data with field data, harm narratives become much more robust. So in this joint study with Zoya Environment Network on a fuel depot in Kalinivka near Kiev, we were able to bring together high-resolution satellite imagery from Maxar with social footage from Telegram, with soil and water sampling data from the State Environment Inspectorate and State Agency for Water Resources. And we were also able to model the likely shape and dispersion of the smoke plume and which settlements were downwind and likely to be effective. Collectively, this allowed us to paint a much more detailed picture of the pollution left at the site and how it had been transported to sensitive locations nearby. So, as you can see, the field of remote monitoring is advancing quickly, but there remain huge challenges, particularly with respect to the collection of evidence robust enough for accountability purposes. So, Earth observation clearly has its limits, not just clouds, but there are limits in what you can understand without ground truthing and contextual information. As you're doubtless aware, social media can be wild and disinformation prevalent in conflict contexts. It inevitably requires experience to be able to filter different sources to verify information, and similarly, martial laws and phone network blackouts can reduce the volume of useful information shared. Baselines are a problem in peacetime, but also in conflicts. We often lack robust data on the pre-existing environmental conditions at sites, and this makes it difficult to determine what damage has been caused by a conflict-linked incident. Attribution, perennial problem in conflicts, responsibility for harm is not always clear. And as noted above, field data is vital, but often difficult to gather in conflict context due to access, costs, and capacity constraints. So the modeling of pollutants, for example, in the air or water, is common in peacetime and could provide some options for evidencing potential harms if models can be admissible. And then there's a question of standards. At present, there is no international standardization for remote assessment or for field sampling. The UN Environment Programme's past approaches for their post-conflict assessments are likely instructive in this respect. So they ensured they used duplicate labs for testing and also had clear chains of custody. Temporality is also a challenge. So particularly for the natural environment, it may take years to fully understand the long-term consequences for species or habitats from damage. Pollution may be more straightforward in that respect, but it may take many seasons to understand how a particular habitat or area has been impacted. Understanding the consequence of incidents on human health remains difficult. There's very poor integration of environmental and health data, and conflicts obviously significantly disrupt health systems and populations. Data sharing between governments, which may have far better access to ground data, and to civil society or other monitoring bodies is underdeveloped, often due to sensitivities around security or politics. And critically, when the nature and scope of future legal processes are unclear because of flaws in the legal framework, the evidentiary needs are unclear, and that leaves those collecting the evidence effectively flying blind. Are we looking at war crimes? Are we looking at reparations? What's the actual pathway here which we're talking about? So those are a few reflections on some of the challenges, and I shall leave it there and hand over to Karen. Thank you.
Many thanks, Doug. And that was a really good point to end on as well, and to draw it all together. That if as we're going to find out maybe a little bit more in a second from Maxim as well, if the law is not as clear as it could be, and as a lawyer it never is, but if the law is not clear in the first place, and the standards and the thresholds, then absolutely, and the process is then absolutely, what are you gathering the evidence for? But there was, I know at the beginning of the conflict, a huge question of how do we gather evidence of the impact of the conflict, of the attacks on various facilities, for example, and I know Doug's team worked, very, very well there, very, very quickly, and with the Ukrainian authorities as well. And I think, so first of all, thank you, Doug, for all of the work that you've done on this and in other conflicts as well. Okay, so I'm going to move on then to our third speaker. So Maxim Popov holds the position of advisor to the Prosecutor General of Ukraine, and has been coordinating the direction of prosecuting ecocide and environmental war crimes in the country since October 2022. Since 2015, he has been an environmental lawyer and human rights defender, focused on protecting the environment through rule of law principles and litigation. Maxim is going to be talking about specifically on the prosecution of ecocide cases in Ukraine during the conflict, during the war. And as I said, he will, I think, be giving his experiences of trying to detail those thresholds and how we can evidence those in the conflict. So over to you, Maxim.
Yes, thank you so much. Hello, good afternoon, everybody. Dear panelists, dear participants of this event, thank you so much for the opportunity to share the information regarding our efforts in order to bring justice for the damage caused to the environment by the aggressor state. Well, I would like to share right now. Do you see on the whole screen the presentation? Good. Yeah, so at the very beginning, I would like to share with you our key principle or our motto in our work. So the motto is that environment should no longer be the silent victim of war. Actually, in the Prosecutor General Office, prioritized this direction, recognize the environment as a victim of war, and allocate quite much resources to the prosecution of this kind of cases. As you may see on the slide, at the moment, the total number of war crimes resulting into damage to the environment is 200 cases. Among these 200 cases, we have 15 criminal cases, incident of ecocide committed as a part of Russia's aggressive war against Ukraine. There are different types of cases and incidents which are in the scope. So here you can see some examples like destroying of forests, freshwater facilities, marine system, civilian objects like food warehouses, oil depots and refineries, and also the protected objects like nuclear facilities. And clear example, which was already been said today by Natalia, is Kakhovka Dam case. There are few legal avenues and let's say platforms where this issue could be addressed. So we actually, Ukraine recognize our primary obligation to end impunity for the most serious crimes of concern of the international community as a whole, and we remain committed to it. That is why we actually prosecute in these cases. In the scope of this accountability mechanism, we believe and hope that International Criminal Court will be also active within the jurisdiction it has over situation in Ukraine. And also there is a possibility to look at this dimension of war from the joint investigation teams and the source states which recognize the universal jurisdiction. Regarding the ecocide, so it's true in our criminal domestic criminal code we have the article 441. Here is the definition of ecocide. So the ecocide means the mass destruction of flora and fauna, poisoning of air or water resources, and also any other actions that may cause the environmental disaster. So as you may see, this definition cover two different parts or kinds of actus reus. The first part is when the consequences is already there, like mass destruction of flora and fauna, and the second part when some actions has been taken by individuals, and this action actually did not lead to any consequences, but they may lead to the environmental disaster. So usually we gives this legal qualification regarding all actions which Russia and its proxies do with our nuclear power plants like Chernobyl and Zaporizhzhia nuclear power plants. So it's considered as ecocide from our side. As you may see, it's also important that Article 441 is included in the chapter of the Criminal Code, which with the name of criminal offenses against peace, security of mankind and international legal order, which makes clear the attitude of the government of Ukraine to the ecocide. So we consider the ecocide as like international crime, in spite of the fact that it's not still recognized. And just, it was already been said that this article has never been used before the war in Ukraine. So I would like also to share some information. So we believe that actually current Geneva Convention and Additional Protocol 1, it gives us some legal avenues for prosecuting the environmental war crimes. So we can use general protections provided to all parts of the environment as a civilian object, being a direct target of attack or resulting into incidental damage. So there is also the option attacks on facilities and installations containing dangerous forces, nuclear power plants and dams, and incidents of pillage, destruction, or seizure, like we have case on sand dredging in Crimea. There are also, here is the information regarding our resources, which was allocated to prosecute these crimes. So we have War Crimes Department, mandated to investigate war crimes, crime of genocide, and crime of aggression, and 9 regional war crimes units in war-affected areas. Also, we have a specialized environmental prosecutors office mandated to investigate ecocide and environmental war crimes. And of course, they are cooperating between each other. And also we have specialized environmental prosecutors in the regions. Also, we are getting legal and technical advice, expertise, and assistance from our international partners. At the moment, we have quite extensive team of international legal experts. By the way, Richard Rogers, who is unfortunately today can't be with us, he's the member of this team, and he is assisting us in our prosecutorial strategy. Here are some data regarding Kakhovka Dam case. So you can see here some consequences of the destruction of the dam itself. So the flooded area is 610 kilometers. 80 settlements were flooded. At the moment, we identified 15 people died due to flooding. It's assumed by scientists, and we already see these consequences, that the impact on the environment is severe. And as you may know, we immediately started the investigation and composed the biggest in history of Ukraine team of prosecutors from 5 regional prosecutors' offices and the biggest team of the investigators. So the team of prosecutors is 172 prosecutors, and the team of investigators is 285. Also, as you are aware, we sent the letter to the ICC and informed them regarding the destruction of Kakhovka Dam. And in 3 days after that, the representatives of ICC visited the area, Kherson region, with the Prosecutor General, and saw the scale of the consequences by their own eyes. So here are some information regarding our challenges. So which was already identified partially. So lack of cases, law related to environmental war crimes in Ukraine before international courts and tribunals, as well as in third states practice. So as far as I'm aware, Ukraine being a first state undertaking efforts to prosecute environmental war crimes and ecocide. Lack of universal definition of the crime of ecocide on international level. Complexity of investigation and evidence collection, which requires high technical capabilities and scientific expertise. Also, since some part of Ukraine is still occupied, it's also a challenge to get there and to gather evidence on the field. And here is the information regarding the priorities of Prosecutor General Office. So effective investigation and prosecution of the environmental war crimes in Ukraine in line with the relevant rules of international humanitarian law as well as international criminal law, rising awareness regarding the environmental crimes committed in Ukraine and damage caused to the environment and its severe consequences, campaigning for similar accountability before ICC and third states for crimes committed in Ukraine and elsewhere, and promoting adoption of the international crime of ecocide. From my side, that's it. Thank you for your attention. I will be ready to answer your questions.
Yes, and thank you, Diakio, to Maxim there. And again, you left it at the position of which Kate, I think, is now going to take up, is that notion of looking forward and broader beyond Ukraine and looking at the lessons learned maybe so far in terms of influencing maybe the development of the notion, the crime of ecocide more broadly. So I'll just give Kate's bio. So Kate McIntosh is the founding executive director of the Promise Institute for Human Rights at UCLA School of Law. She established the first Promise Institute at UCLA, where she led work at the intersection of environment and human rights and convened the Promise Expert Group on International Criminal Law and the Protection of the Environment. She was deputy co-chair of the independent panel for the legal definition of ecocide, and so obviously is well placed to talk to us today about how that definition maybe was conceived, but as I say, more broadly now as the developments, I think, coming from Ukraine. So I'll throw the floor to Kate with ecocide, human rights, and Ukraine.
Thank you so much, Karen, for the invitation, and thank you, Natalia, Doug, and Maxime, for the fascinating presentations. I've actually already learned a lot in this seminar so far, so that's a bonus. And maybe just to say, Natalia and Maxime, it feels like a small beacon of hope in the midst of the horror of what's going on in your country, to see that such thorough work is being done on accountability, and in this particular case for damage to the environment. So, my congratulations and support. So I'll talk about what an international crime of ecocide could add to the protection of the environment in and related to armed conflict, specifically perhaps in the context of Ukraine. And I'll be speaking in terms of the definition which we proposed in 2021 as the independent expert panel, which Karen just referred to, which was convened by the Stop Ecocide Foundation. And as you said, Karen, Richard Rogers, who couldn't join us today, sadly, and I were deputy chairs of that panel. So first of all, I want to be careful not to undermine the important arguments which ICRC and others have been making for some time, which is that there is, as we heard, so powerfully detailed by Natalia, an existing and significant body of law protecting the environment in armed conflict already, including through international criminal law in the form of war crimes. And this has been distilled in the ICRC guidelines on the protection of the natural environment in armed conflict, which have already been referred to, as well as, of course, by the International Law Commission in their draft principles on protection of the environment. So I just want to leave that there, because the ICRC in particular makes the point that it's not so much the inadequacy of the law, but, as Natalia referred to, rather the failure to implement and enforce that law and to respect that law, of course, as we've just heard about in particular. That's more the problem. However, that being said, an international crime of ecocide, as proposed by our panel, would have some additional protective elements to those that are currently provided by international humanitarian law and international criminal law. And I'll just run through those quickly. So first of all, as I'm sure the listeners are aware, the war crime in the Rome Statute has a proportionality threshold, which is generally seen as being very high, and is perhaps one of the reasons that we haven't seen a prosecution of environmental crimes at the International Criminal Court so far. So in the Rome Statute, the prohibition is of widespread, long-term and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct and that's understood to be, a very high threshold. And it means that there's considerable scope to argue about military advantage and whether the destruction can be justified, which weakens that prohibition. And I should say that the ICRC has taken the position that actually widespread, long-term and severe damage to the environment is an absolute prohibition. But that is not reflected in the Rome Statute, Article 8, 2b4. So the crime of ecocide that we've proposed does not have that threshold. It is not proportionate. The amount of damage that is permitted is not proportionate to military advantage. So that is something that the new crime of ecocide, would add in terms of protection. The crime that we propose also has a slightly lower impact threshold. So we propose severe and either widespread or long-term damage to the environment. And that was after a lengthy discussion about whether to import the severe, and widespread and long-term element into the crime. And, we were convinced as a group by heartfelt arguments by some of the panel that was too narrow and that we did need to encompass situations in all cases which had to be severe, of course. But it was possible to conceive of situations which we felt would rise to the level of ecocide that could be long-term, perhaps even permanent, but not necessarily widespread. And conversely, very widespread, severe damage that wouldn't necessarily fit a determination of long-term. So we also have that alternate formulation. And just to mention, of course, the NMOD Convention, which Natalia talked about, includes those three qualifiers, but all three in the alternative. So it's a lower standard still. So for the international crime, we are higher than the NMOD Convention, which has severe, widespread or long-lasting damage, but it's lower than the Rome Statute or the additional protocol. Importantly, in our definition, we have another criteria, which is that the acts have to be unlawful or wanton. And actually occurred to me in preparing for this presentation. I mean, and we've reflected on this before in the panel. To the extent to which unlawful may import actually some of the provisions of IHL into the crime of ecocide in armed conflict. When you're looking to what is lawful in armed conflict, of course, one would traditionally look to IHL. So there's an interesting puzzle there about how much the IHL standard would be imported into the ecocide definition in the Rome Statute in armed conflict. But we have then an alternative. I mean, I think it's unlikely that would include importing a whole nother threshold criterion, but it may mean that acts were not found to be unlawful. And that you would therefore be looking at the alternative criterion, which is wanton. Wanton, of course, is a familiar term from IHL, but we provided a definition which we thought would be helpful, which was with reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated. So if we think about the war crime in the Rome Statute, we had that balance between the damage and the military advantage anticipated, and we've mirrored that to a certain extent in our provision with a balancing against social and economic benefit. And that was because, of course, we do damage the environment as we live with the environment. The goal, of course, is to live with the environment in a sustainable way. but there will be, harm will be done, trees will be cut down, rivers will be diverted, etc., as part of our interaction with the environment. The point is that it would have to be done in a sustainable way. We wanted to make sure we had a realistic definition. So if we think about the kinds of atrocities that we've been hearing about in the panel today, for example, the Kachowska Dam explosion, clearly, whether or not that is found to be lawful under IHL, and of course there's a lot of weight to be given to the argument that that was unlawful under IHL and indeed a war crime, but even if it were to be found to be, it seems very unlikely that the extent of the damage that was caused by that explosion could possibly be justified by any kind of economic and social benefit. I mean, that's just, it was not done within that framework. Those acts were not considered. So in that particular, with that particular lens, an international crime of ecocide could really increase protection. And finally, our proposed crime explicitly includes anticipated harm, and I was really interested to hear Maxime highlight that element of the Ukrainian definition, which I hadn't fully appreciated, that there's also this provision of anticipated harm. So yeah, I wish I had understood that earlier, but that's really good to know that we followed in our proposed definition a precedent that's already there from Ukraine. So thank you for educating me on that today. So in our definition, the criminal acts are acts committed with knowledge that there is a substantial likelihood of that severe and either widespread or long-term damage resulting from those acts. So in the case of the dam, for example, all of the damage that we can anticipate resulting from that collapse would be included in the threshold assessment, assuming, of course, that the destruction of the dam was a deliberate act. So I think that's where a crime of ecocide would add to the international law, just reflecting on the fact that, of course, Ukraine has this crime in its criminal law, which is being investigated, as we've heard, albeit with this slightly different standard. What difference would it then make if those damages could be prosecuted as ecocide as an international crime? In other words, okay, we've got war crimes. If it doesn't fall into war crimes, it may fall into the national Ukrainian crime of ecocide. Why would we need an international crime of ecocide? Well, my answer to that question would be, I guess, threefold. First of all, of course, there's the venues for prosecution. So the International Criminal Court, if it had ecocide in its statute, would be able to prosecute that crime, and potentially other states might be able to prosecute it under universal jurisdiction if they were to adapt their laws accordingly. At the International Criminal Court, of course, there's also potential for reparation for victims. So if ecocide was prosecuted as an international crime, there would be access for victims to the trust fund or to orders for reparations from the International Criminal Court. And finally, I think the expressive or emblematic value of such destruction being seen to be an international crime. And again, really interested to hear Maxime talk about how ecocide is in that chapter of the criminal code in Ukraine. So it is seen as an international crime already. But global recognition of that fact, that ecocide, that severe and widespread or long-term damage of to our environment is on a level with other international crimes, is a matter of international concern, I think would play a really important role in raising awareness, in accelerating prevention, in possible deterrence, and in eventually increasing protection for the environment. So I'll leave it there and look forward to discussing with colleagues and the audience.
Well, many thanks, Kate. That was, again, another, I think, very rich mapping of not only how the expert panel came up with the definition. I think that was really interesting. And I should also shout out to Christina Voigt, who was on the panel, of course, knows the chair of the WCEL, the World Commission on Environmental Law, of which myself and Daniela and a few others on the call are members. So yes, again, a rich discussion, bringing, I think, to a close our 4 panelists. And we've heard about the laws more broadly, so the IHL, the ICL laws. We've heard then at the national level what Ukraine has in its criminal code. drawing from the international, but also, of course, adding in the area of the specific area of ecocide. And then we heard from Doug, of course, who brings that monitoring and evidencing dimension. So at this point, I think, so I'm just checking my notes. I think we don't have any more specific talks.